Good evening, everyone. My name is Lauren Kistel. I am a Senior Vice President with CAMCO Management. Thank you all for joining us this evening on this cold and snowy evening. It's first time in a couple years we can say that. Our presenters this evening are Marcus and Hoffman, Rob Hoffman and Robert Casulo. They will be presenting on Act 115. This pertains to Pennsylvania, and then also annual meetings and elections. As a couple quick housekeeping items, please keep yourself on mute during the presentation, just to cut down on background noise. If you have questions throughout the presentation, we do intend to make it a bit interactive, but you can put those into the chat or raise your hand, and there will be a couple different points throughout the presentation where questions can be asked. Without further ado, I will turn it over to Rob Hoffman.
Hello, everybody. Thank you for taking time out of your evening to listen to a bunch of lawyers, or two lawyers, which I guess is a bunch, talk about the law, which is not the most dynamic or exciting things. But we hope that tonight's presentation has some information that you'll find useful that you can utilize in your own governance of your own association. So little shameless self-promotion for 15 seconds. Marks and Hoffman works with homeowners and condominium associations throughout southeastern Pennsylvania. We represent approximately 400 or so associations. And we do everything for them, from complex litigation to document review and amending documents, et cetera. So if it's associations, that's what we do. And one of our key team members at the firm is Rob Casulo, who really put tonight's presentation together. His name should come before mine. He did a great job. He's one of our key employees and a really important part of the firm. And one of the things that Rob works with and focuses on especially is amending documents, drafting documents and contracts and things like that. And Rob has a very strong understanding of this material. And we have a couple of different sections of things that Rob and I are going to talk about tonight. And each section will stop and we'll see if anyone has any questions, because it's always better, I think, if you can ask questions as you go along and have it more meaningful. So with that said, I'll turn it over to Rob Casulo to go through what Act 15 is and annual meetings and elections.
Thank you very much, Rob. Again, my name is Rob Casulo. Thank you, everyone, for joining us tonight. I will do my best to make this presentation as exciting as I possibly can. As Rob and Lauren alluded to, this is going to be talking about the new Act 115 legislation, as well as its impact on annual meetings and board elections for HOAs, condominiums, and cooperatives, throughout Pennsylvania. So, let's start. There we go. All right, so the first bit that we're going to talk about is, what is Act 115? Act 115, the what? Act 115 was an omnibus amendment to the Pennsylvania Uniform Condominium Act, the Uniform Planned Communities Act, and the Pennsylvania Uniform Cooperative Act. Omnibus amendment, more or less, essentially just means that the legislature amended all three of these different statutes in one fell swoop by signing Act 115 into law. So it was signed into law November 3rd of 2022 and then became effective on May 2nd, 2023. So some time has passed, so it is currently in effect and applicable. So as you'll see tonight, Act 115, the changes made under Act 115 essentially can fall into two categories. The first are mandatory categories or mandatory provisions that impact every association, throughout Pennsylvania pretty much. And the second are the discretionary provisions, which we will be getting to a little bit later in the presentation. So probably the biggest sweeping change from Act 115 has to do with the way that unit owner votes are tallied. And Under Act 115, it's changed all three, again, the Condominium, HOA Act, and the Cooperative Act, to now provide that the master declaration must provide that votes cast in an election for board members are submitted to an independent reviewer who will then tally the results of the election, certify the results to the executive board. So this requirement only applies to master associations and/or associations that are comprised of at least 500 units. Now, if your association has less than 500 units, you can opt in if you'd like to be subjected to this new requirement by a majority vote of the unit owners. Again, that's discretionary though if your association consists of less than 500 units. For those associations that satisfy that 500 unit threshold, it requires that once the votes are tallied and certified by the independent reviewer, the board then presents the votes of the election results to the unit owners at a meeting. Can be the same meeting or a subsequent one, and again, applicable only to associations with at least 500 units. Now, one of the most important things here is that there are also requirements in terms of what is considered an independent reviewer under the Act 115 legislation. So it can either be a certified public accountant, an attorney, or an official vote management system. The independent reviewer cannot be a unit owner, either directly or indirectly, have an immediate family relationship or tie with the declarant, a unit owner, or the manager, has no shared financial interest with the declarant, a unit owner, or the manager. And if the independent reviewer is compensated either by the declarant, a director, or the association, or the manager, the terms of that compensation have to be released to all of the unit owners at a scheduled meeting. So essentially what this first mandatory provision provides is that for associations of 500 or more units, moving forward for board elections, they essentially have to get a third party to come in to help certify and tally all of the votes. And that whole process has to be done in accordance with the new terms under Act 115. And with regard to those associations, as we'll talk about in a little bit, changes actually have to be made to the governing documents to ensure that it's consistent with the Act 115 legislation.
Hey, Rob, there's a question from the chat, and the question is a management company considered an independent reviewer?
So no, it has to be either a certified public accountant, an attorney, or again, a vote management system. So I guess the question would then be is whether or not a property manager would be considered a vote management system, but I would say most likely no. That also, just if you look at the remaining criteria in there, it indicates that really they want this third party to not have that close of a tie with the association. So I kind of think it would be against more or less the spirit or the intent of Act 115 if the property manager served as that independent reviewer. Additionally, some of the other changes under Act 115 have to do with board removal. Now, this change was only applicable to the Condominium Act because similar language was already existing under the UPCA and I believe the Co-op Act. But as revised by Act 115, now under the Condominium Act, notwithstanding any provision in the declaration or bylaws, to the contrary, a board, either a board member or the entire board, can be removed from office by 2/3 vote of all unit owners present and entitled to vote at any meeting of the association at which a quorum is present. This can be with or without cause, and it is subject, it says again, provided that notice of the intention to remove a member of the board is given with the notice for the corresponding meeting. I bring that to your attention just because that is unique to the Condominium Act. As of now, the UPCA for planned communities does not have that notice requirement in it. So it's just the Condominium Act. And I just want to stress again that it's 2/3 vote of all persons present and entitled to vote at the corresponding meeting, not 2/3 of all the unit owners, you know, throughout the entire association.
Yeah, so I think it's just worth highlighting here two things very quickly. You have to have quorum. So if you have 100 units and you have 10% quorum, that's 20 units. And so that's 2/3 of those 20 units in a condominium can remove the board, as long as there was notice of that along with notice of the meeting. And in a homeowners association, 2/3 of those 20 owners, without any prior notice, can move an HOA board. They can just remove it. It's pretty interesting. It's always, well, it's been like that on the HOA side, community association stuff, for a long time. I've never had that happen, knock on wood. And then the other thing I'll just mention to you is we're going through this. Remember, you have your declaration, which is like your constitution. And a lot of the changes that we're talking about need to be made in the declaration by way of an amendment if it's a mandatory change. So you have your declaration first. Underneath that, you have your bylaws, and underneath the declaration and the bylaws are the rules and regulations. What sits on top of the declaration and the bylaws and rules is what the state law says. And that's what Rob's going through tonight. So you have what the state law says, and then how does that impact your declaration, which is like your constitution, or your bylaws? And many of the changes that Rob's talking about actually get made in the bylaws.
It's kind of consistent with what Rob H was saying. If you look at the very first word in this provision, notwithstanding any provision of the declaration or bylaws to the contrary. So again, essentially what that means is, you know, it doesn't matter what your declaration or bylaws currently says. This provision in the act right now is what is governing in terms of board member removal. So as Rob mentioned, a lot of the changes that we end up making to governing documents pertain to to ensure their compliance with Act 115 pertain to the bylaws. And this right here is probably one of the most significant changes under the Act 115 legislation that we've seen, is that now the bylaws may be amended only by the affirmative vote of at least 51% by unit owners to which, or owners of units to which at least 51% of the votes in the association are allocated, or a larger majority, or a smaller majority if the units are all restricted to non-residential use, which I don't know if I've ever actually encountered that. But so the reason why this was significant is with regard to a lot of older associations. A lot of times, some of the older associations, you'll see in their bylaws that they will grant, for instance, the board the authority to unilaterally amend the bylaws without getting unit owner approval. And actually the act used to contain similar language indicating that. But as of the implementation of the Act 115 legislation, now the bylaws may only be amended by the vote of at least 51% of the unit owners in the association. Additionally, the vote for any substantive amendments to the bylaws may only be taken at a scheduled meeting. And the notice for that meeting has to have been circulated at least 14 days prior to the date that the meeting is scheduled for. The meeting and the corresponding vote are scheduled to take place. Again, previously there were no minimum requirements in terms of the notice. And also, again, some bylaws have previously provided that the board was able to execute substantive amendments without unit owner approval.
Rob, there's a couple questions
Oh,
coming
yes.
in about whether what qualifies for attendance. Is it in-person attendance? Is it Zoom attendance? Does it matter under the act?
We will actually be getting to that in a couple slides.
I'm jumping ahead. I'm so sorry.
No worries.
It's a good question. Yeah, definitely.
Another change is that now the act, all the acts as changed by Act 115. We use the word act a lot in this presentation. Requires that you provide that associations provide pre-election sessions by request. So the language that you've been seeing in all these slides is taken right from the Act 115 legislation and the provisions that are in the acts. So now the bylaws of an association must require that upon request of one or more candidates, the association hold a special session at least 7 days prior to any board election. That essentially allows, calls for a meet and greet, or allows candidates to, stand up and speak about themselves, answer questions from unit owners, and so that the unit owners get to know each of the candidates. Again, it also now requires that each candidate has an equal time to address the unit owners during a special session under this provision.
So this is important to note. So this applies to all communities and it's mandatory.
Yeah.
So in your next election cycle, if somebody requests this, you have to do it. Number one. Number two, the bylaws must be amended to add this language in it. This is one of the mandatory provisions. So you should talk to legal counsel, your manager, and make sure that you do an amendment to your bylaws to allow to add this language. Okay, it's really, really important. And finally, as far as what communities that we work with are doing, they're having an actual meet the greet, and they're doing it live and via Zoom. And they give each candidate 3 minutes to talk or 5 minutes to talk, to do a presentation, and then it's just like a round table. And
Rob, can I ask a question without going into chat? It can be live, right? Because we have so many homeowners who want to have something in person. So it can be the meet and greet. It's not going to have to be on Zoom to count.
No, it should. I think industry standard is best practice is to do it live. Number one, it's a great question, but also to include a Zoom option.
Right. Okay.
So that you can have both, because we're turning into a Zoom society for good or ill. But that seems to be what most of our communities are doing, unless they're particularly small and they can do it easily live.
Okay, great. We have a number of people, even with our elections, who want in person, at least that once a year type thing. I'll get to that when you get to that part, so as not to hold up the other Rob. Go ahead, Rob. We can't hear you.
All right, Rob C., you're up, buddy.
All right, here we go. Additionally, under Act 115, it changed the provisions governing quorum. So now if an association fails to meet a quorum at 2 subsequent meetings under any of the 3 acts, then the association is able to rely on the provisions under 5756B of the Nonprofit Corporation Law, Pennsylvania Nonprofit Corporation Law. So what that means is under 5756B of the Nonprofit Corporation Law in Pennsylvania, if it's a meeting at which directors are to be elected, that has previously been adjourned due to a failure to satisfy quorum, the unit owners or individuals present at that meeting shall nevertheless constitute a quorum for the purpose of electing directors, even if a quorum is not actually satisfied. So that, again, only pertains to meetings that are being conducted in order to elect directors to the board. Number 2 is that if, again, same thing where quorum hasn't been satisfied, after 2 subsequent meetings. So there's a notice requirement, essentially, if the meeting does not have to do with the election of the board of directors. And then similar language. So you just have to make sure that the 3rd and final meeting, if, again, you've been unable to meet quorum at 2 subsequent meetings, you have to make sure that notice is adequately sent out, that the items for business or items for discussion are outlined in the notice. And then whoever attends that makeup meeting or that 3rd meeting constitutes a quorum, even though It's even if it doesn't technically satisfy it under the documents. Right. So those are all of the mandatory provisions. At this point, we'll be going into some of the more discretionary provisions. All right, so these are the discretionary items, and now some of them do have caveats that I'll talk about. But the discretionary items pertain to electronic voting, absentee ballots, recording of association meetings, electronic notice, remote meetings, and then election by acclamation. Electronic voting and absentee ballots. So now it's been codified in each one of the acts that unless it's expressly prohibited in an association's governing documents, unit owners are able to cast votes electronically or by absentee ballot. And then obviously by in person or by proxy as they've always done, or another method of voting that's expressly called for under the association's governing documents.
Oh, Rob, this is what I was waiting for. We have always an issue with my former real estate law professor sent me the copy of House Bill 1175 last year, and it stated, thank God, absentee ballots. We have a problem back and forth with. We have people who want to vote with paper ballots, and I think they should. I don't think living here at Riddle Glen, you have to fight for the right to vote. There are people, believe it or not, who don't have technology, who don't want to use it, who do too much at work. They want to vote with paper. I called our law firm, Richter and Clemens, and Stephen Richter said, yes, we can have paper. Can you guys put it up? Can we vote with paper ballots?
Yeah,
Sure.
absolutely. It's interesting. This is worth taking a minute to talk about. So, Act 15 aside for a minute. The governing documents of your association will state how you can vote, and it'll state how you establish quorum. And it's usually in person or by proxy. The term absentee ballot before this Act 115, people use that term a lot. And I would say that over the 400 plus associations that we represent, maybe 3 allow absentee ballots specifically in the documents. And of those 3, none of them state that an absentee ballot counts towards quorum. Okay, so what do? What we do is we draft something called a directed proxy. Basically, it's a directed proxy. Proxies are valid. Proxies always count towards quorum. So we take what would normally be an absentee ballot and you just change the title and put directed proxy, have the unit owner sign and date it. And basically what the unit owner is doing is saying, I, unit owner, hereby proxy my vote to the board, and the board of directors shall cast the vote exactly as follows. So it's a directed proxy. The board has to count. It's essentially an absentee ballot that counts towards quorum.
So therefore, we do have proxy and absentee kind of were used in the same way. But with the proxy, I've had owners who want to hand it to someone to give to someone on the board, or they'll say, I can't go to the meeting. Can you hand it to someone there? Can they hand it to a homeowner?
Yes. And what we generally say in the directed proxy that we put together, it lists all the unit owners' names. It tells you how many you can vote for and pick, and et cetera. And then it says you turn this in by mailing it, by scanning it and emailing it, taking a picture of it with your phone and emailing the picture. And we have the information in there, and all of that's valid way to do it. So you can use paper. Paper's great. We also encourage people and our managers and boards, if you're worried about quorum and you're having an annual meeting, and then bring blank directed proxies to the annual meeting, because if you're at the meeting and you have too few people to have quorum, you can't have an official meeting. You can have an informational meeting and go over the budget and stuff, and you should because everybody's there, right? But you can't have an official vote because there's no quorum. So what we say is bring blank directed proxies so that anybody there who's not yet filled out a directed proxy can do so and cast their ballot. That way, when you come to the next meeting, you have a better chance of getting quorum. But now Act 15 comes along and it expands our current practice of using directed proxies. It still talks about absentee or electronic ballot. The law's not exactly clear in defining all of these things. So our recommendation is to remain either with an electronic voting system, which they're starting to be rolled out, or stick with a directed proxy that the owners either hand in, mail in, scan an email, or take a picture and email in. And then that all counts towards quorum.
So, Mr. Hoffman, I have another question about the paper ballots. What I have homeowners who over the years, everybody used to think I was on the board because I'm visible and approachable, and I'm one of the few on-site owners. They want the ballot mailed along with the candidate statements and everything else. We seem to have a problem with that. Everyone wants to do everything online. People want to look at the statement and go, oh, this candidate says this and this. How do we make our associations, okay, mail out the packet with the statements, the forms, everything? Do you see what I mean? I think it should be a requirement. They want to vote. Living at Riddle Glen shouldn't be a job. You know what I mean? They should be able to vote. If they want to vote in paper and they want the packet mailed, like a actual postage mail, not email.
Yeah, that's a notice of the meeting has to go out in accordance with the notice requirements of your governing documents. Most of the governing documents don't say to email that notice out because email wasn't around when the documents were drafted.
We've been generally having the problem where it's been emailed. It's like you could print it. It's like these people don't want to have to go. Not everybody has a job where you can just go into work and print and copy and fax and scan. We want to make it easy. Could they still do paper? I'm sorry. You got more people.
No, it's okay. Yeah, Karen. So yours does sound like a little bit of a specific association issue. I'm happy we can work this out certainly with your property manager and the director for Riddle Glen moving forward, just to make sure that it's a seamless process for all involved.
Yeah, thank you. Sorry, take your time.
No, it's okay.
Can you get us your, I guess, email or something so we can find you again or something? I think I have.
Absolutely. I have your contact information. I'll reach out.
Okay, thanks, Lauren. I better answer my door.
Moving forward. So again, defines the term electronic ballot. And again, ballot casts are given by electronic transmission over the internet, a vote management system, or the association's community network, whether by direct connection, internet, telecopier, electronic mail, or other technological means. It essentially covers every way you could think of to, at least that exists now, to electronically submit a ballot or a vote. Now, with that said, there's some caveats here in terms of the use of electronic voting and absentee ballots. An association can only permit unit owners to cast a vote electronically if it is able to identify the unit owner, confirm the identity of the unit owner submitting the ballot, and if whatever the method is, can generate a receipt of the ballot and its electronic submission or transmission, if it can generate that, to provide that to the unit owner. So again, while this is a discretionary provision, there are some requirements that come along with it. Essentially, whatever electronic voting method you use, like a vote management system, they have to be able to provide the unit owner with a receipt showing or confirming that they cast their vote electronically. And it has to have some mechanism to allow the association to verify the identity of the unit owner who's casting the vote electronically. Someone brought up quorum earlier. Now, as changed under Act 115, an absentee or electronic ballot or vote is counted as a unit owner being present and voting for purposes of establishing a quorum. However, it will not be counted, and this I feel like is kind of redundant, but I'm glad they clarified it, will not be counted if the unit owner ends up physically attending the meeting and casting a vote at in person at that meeting. So that would supersede any electronic vote that may have been previously submitted. But the big one is that first item where now an absentee or electronic vote is counted towards calculating quorum. Additionally, the association is now permitted to record association meetings, or at least the board is able to record association meetings, either with audio or video. However, the board has to make an announcement at the commencement of the meeting, letting all the unit owners present know that the meeting is being recorded. And then this also triggers some records retention obligations on the part of the association. If and to the extent that an association meeting is recorded, the Act 115 legislation requires that the association maintain a copy of that recorded meeting for at least 6 months after the date of the meeting, and it has to be made available upon request of a unit owner. Additionally, with regard to notice, associations are now permitted to send notice of meetings or community events electronically, so via email or some other electronic method. So long, however, as the association has gotten the prior written consent of the specific unit owner, or where the bylaws all automatically permit electronic notices. I've seen a handful of bylaws, maybe 3 or 4, that have provisions that expressly permit notice to be sent via email or other electronic means, but especially for those older associations, it's not that frequent. So in terms of the electronic notice, one thing that we've been recommending is that associations or boards consider including what's called a electronic notice acknowledgement and consent form in the resale materials. Now, this is just for for new unit owners coming into the community. This way, when they're given the resale materials, they have a copy of a form that they can sign and submit back to the manager or board, essentially giving their consent to receive notice electronically, while they're, for the time being, or while they're a member of the association.
Another thing that you want to pay attention to is as the different management companies are utilizing a website for the community to share information and to schedule and inspections and really great information through the websites. The consent to use that website may contain some of this language of where you're consenting to electronic means. So you would want to be careful to look at that. And this is not a mandatory provision. This is an optional provision. So the board of directors would have to decide to try to implement this. Then it would have to be implemented. If this is not implemented, there are laws against recording of meetings, private meetings, without everybody's consent. So unless you have this implemented and part of your governing documents, and you strictly adhere to the retention, then recording in meetings might not be the best way to go, just to comment on one of the questions in the chat.
Except as otherwise provided in the bylaws, an individual may participate in either a meeting of the association or the executive board by means of conference telephone or some other remote electronic technology, so long as whatever that technology is allows all the participants in the meeting to be able to hear and understand each other. And again, participation, so just to take a step back, now it's been codified in each of the acts that that you can have like a virtual annual meeting, or a board meeting through Zoom, or even, like I said, an annual meeting through Zoom. Which again, this would have been great if they had done this prior to COVID-19 back in 2020. But and again, to the extent that you do allow remote participation in meetings, Anyone participating via Zoom or whatever, some other electronic means, is counted as being in attendance at the meeting. So that would be, for instance, for purposes of calculating quorum. Again, another caveat. If and to the extent that your association wants to take advantage or utilize remote virtual meetings of either the board or the association, then you have to make sure that your bylaws are amended in order to include these provisions establishing how notice of virtual meetings of the association is going to be provided. And again, this language is right from Act 115, expressly states now that the bylaws must require, and then goes through, first class, express mail, essentially more classic notice, or fax, email, or other electronic communication. Again, provided the unit owner has agreed in writing to accept electronic notice, or where the bylaws expressly permit electronic notice to be given. In addition, under Act 115, all of the statutes have been amended to address circumstances where you're having an uncontested election. In that case, as used under Act 115, it's referred to as an election by acclamation. And generally speaking, unless the bylaws specifically state otherwise, in the event that there's an election for a position on the board is uncontested, or if there's more open seats than there are candidates, then the officer or chair presiding over the meeting may declare that the nominee or nominees are elected by acclamation, which essentially means that you wouldn't have to go through with conducting a vote if it's uncontested, and who's come forth as a candidate is more or less going to be a shoo-in as winning. But again, if you look at the very end of this provision, after determining that there are no further nominations. So it's very slight, but that is a reference to associations where their governing documents permit unit owners to be nominated for election from the floor at the meeting, at the voting meeting of the board. If that's the case, then prior to the officer or chair declaring that the nominees have been elected by acclamation, the first they have to make sure that there's nobody present who would want to submit an additional nomination from the floor. Here we just have a quick comparison in terms of the mandatory versus the discretionary provisions. Mandatory, we have the vote tallying and certification by an independent reviewer if your association consists of 500 or more units. We have the board member removal provision, the bylaws amendment process, pre-election sessions for board candidates, and then the quorum requirement issue. Discretionary, we have vote tallying and certification by independent reviewer. If less than 500 units, then again, remember, you can opt in with 51% vote of the unit owners. Electronic voting, absentee ballots, recording of meetings, electronic notice, and remote meetings, with the caveat that if you do choose to proceed with remote meetings, then it triggers that mandatory provision where you have to have the specific notice requirements in your bylaws, and then elections by acclamation. So kind of the big one now is in terms of it's complying with Act 115. So what do we have to comply with? For associations that consist of 500 or more units, we have to look at the vote tallying and certification by an independent reviewer. If your bylaws either have have a unit owner approval requirement that is less than 51%, or if they don't contain the 14-day notice requirement, or if they allow the board to unilaterally amend the bylaws without unit owner approval, then we're going to have to look at the bylaws amendment process. pre-election sessions, again, if not already provided for under the bylaws, and the remote meeting notice requirements. Again, to the extent that an association wishes to utilize virtual or remote meetings, but that is not a requirement. So how do we do this? We do this through technical corrective amendments to your bylaws. Each of the affected statutes contains a provision authorizing the association's board to unilaterally amend either the declaration and or the bylaws without unit owner approval in order to ensure that the governing documents are in compliance with the applicable law and or in order to cure, let's say, an ambiguity or a conflict that currently exists. There's also a requirement that prior to doing so, the board has to get a written opinion from legal counsel who is separate from the declarant, just confirming that whatever the proposed technical corrective amendment is consistent or in compliance with the terms of the corresponding statute. And again, just on the right, more or less a summary of what I mentioned is that to the extent that your bylaws or the declaration for the larger communities is either inconsistent with or does not currently contain some of those mandatory provisions, then that's where we might come in to provide some value in terms of looking at everything, providing an opinion as to whether or not we believe a corrective amendment is appropriate in order to make sure that the documents comply with Act 115. And then, assuming that's the case, at that point, the board would execute the technical corrective amendment to the declaration or bylaws. And at which point it would, if it's to the declaration, once it's recorded, it would go into effect. If it's the bylaws, once it's executed by the board and circulated to the unit owners, it would then go into effect. Just some practical considerations in trying to navigate, through all of this with regard to planning annual meetings and elections. First, probably biggest step is determine how many units are in your association. If your association consists of 500 or more units, then that triggers the vote tallying and certification and the need for an independent reviewer. Number of candidates is that would trigger, again, a potential election by acclamation, but then you also have to ensure that your bylaws contain that language we discussed earlier with regard to pre-election sessions, call it the meet and greet language. Also, quorum requirements. Prior to an annual meeting, I think that's one of the biggest questions that we have from a lot of managers is, hey, we haven't had a lot of great turnout recently. We have a board election coming up or something like that. What can the board do to try and make sure that we meet quorum so that we can, proceed with all of this? Again, Rob talked about it earlier, but we almost always recommend the use of directed proxies for that. And then in the event that a quorum is not satisfied and 2 meetings have been adjourned, again, under Act 115, if it is an election meeting, then at the 3rd meeting after that, whoever is present will be deemed a quorum, even if technically less than a quorum. If it's a non-election meeting, then that triggers the notice requirement that I discussed earlier, in which the notice that's being sent has to explicitly state that the unit owners who attend the adjourned meeting are going to constitute a quorum for purposes of completing, whatever the action is that's stated in the notice. And again, just some more practical considerations. What method of voting are you going to use? Electronic voting. If your association is interested in using electronic voting, then again, that triggers a couple more caveats where you have to be able to confirm the identity of each unit owner who submits a vote electronically, and whatever vote management system you're using has to be able to provide the unit owner with a receipt of the electronic transmission, and the ballot has to be made available to the unit owner if not automatically provided. Also, again, Karen, I think to your point, a lot of associations prefer conduct votes either in person or by proxy, and aren't really interested in going with the electronic voting method, which is fine if that's the case. We always recommend that directed proxies contain language that is specifically tailored not to discount unit owner votes.
Well, we
Meaning,
have the opposite here. We have people that want the paper ballot. We have electronic, and there are people who are not happy with it. So that we want a paper ballot sent. That, I guess that's Lauren will get with me about. We just need it sent in the mail. That's all these people are begging for. Just send it in the mail so we can vote, and they'll send it back whatever way CAMCO wants.
No, as I mentioned again, all of our directed proxies, we make sure it contains language that does not discount unit owner votes, because it just in the event, and again, Rob, correct me if I'm wrong on this, in the event that a unit owner is seeking, does end up trying to challenge either an election or amendment or whatever action was taken, the last thing that we want is for a court to think that essentially the association was putting up barriers or otherwise trying to interfere in unit owners having the ability to vote on association matters.
Thank you. Yes.
Yeah, that's right. And it's funny because some of the problems are just self-inflicted and completely unintentional. And they're not really a problem until somebody raises the issue. I'll give you a good example. Our directed proxies years ago used to read, in order for your directed proxy to be counted, it must be received by 4 o'clock Thursday, say, right? But what if it comes in at 4:03 and you still happen to be there, right? Well, I really hadn't thought about that at the time, and somebody said, well, you can't count that ballot because it came in after the 4 o'clock deadline. It's not fair. I said, no, we're going to count it anyway. And in that particular instance, years ago, it didn't matter because it was so overwhelming that the issue wasn't an issue, right? But after that, we changed how we do it. And so now what we say is, in order to assure that your ballot is counted, it must be received by. So rather than saying, in order to be accounted, here's the deadline. If it's after the deadline, the inference is it won't be counted. We've changed it to say, hey, make sure you get it to us by 4 o'clock to assure it will be counted. 4:03, 5 o'clock, it'll still be counted so long as logistically the manager receives it and takes it to the meeting. In fact, the directed proxies can be handed in at the meeting as long as they're received prior to the vote being counted. Yeah. So nothing's a problem till it's a problem, until an unhappy homeowner that is challenging the election, or an attorney who wants to challenge the board's validity because the board made a decision that his client doesn't like, goes all the way back to, let me see if this board was even validly elected. Was there quorum? Was there not quorum? Those sorts of things. So it's important to carefully review the documents that you're utilizing, make sure that your manager and legal counsel go over them so that it's easy and inexpensive to avoid the problems, much more expensive to fix them afterwards.
Thanks for clearing that up. Thanks. And thanks, Lauren. I'll get with you sometime next week.
Next item is meeting platform. Again, is the board looking to conduct it, through a remote or virtual platform, as is now, permitted under all the statutes, or in person? Again, if the board does, or even some combination of the two, but if virtual or remote participation in an association meeting by unit owners, if that is permitted, again, that triggers the requirement that the bylaws contain specific notice contain these specific notice requirements that I spoke about previously. Even if the current board, has no intention of using, remote or virtual meetings, it might not be a bad idea just to think about making sure that the language is still, included in the bylaws. Just this way, you do have that flexibility in the future in case some issue comes up. And again, needing notice. If not already provided for under your governing documents, to the extent that you want to provide electronic notice of the meeting to unit owners, you have to make sure that you have their prior written consent. Just something that Rob and I kind of threw in here because we wanted to talk about the importance of it is the need for a staggered board of election or board of directors. Just, as a brief overview, is, staggered board is comprised of directors that have different overlapping terms, so that essentially not all board members, seats are up for election or expire in the same year. It helps to minimize board turnover, but it also helps to minimize interference with the association's operations, so that you're not going from, a board consisting of, let's say, 5 members who've been serving for 3 years, have some experience under their belt, and then all of a sudden you have 5 unit owners who've never served on a board before. And then, I don't know if there's anything else, Rob, you wanted me to touch on with regard to staggered board.
No, I mean, oftentimes it doesn't specifically specify that in your documents, or maybe it does, but the boards become unstaggered. People step off and they're not elected. So if you're serving on a board or your community, if it's 5 board members and it's a 2-year term, you have 3 people up 1 year and 2 people next year. Or if it's a 3-year term, you have 2 people up, 1 person up. That's just what we mean by staggered. But it's really important to keep that institutional knowledge of what decisions have been made and projects and stuff like that. And the other thing I'll say is, as far as institutional knowledge goes, when Marks and Hoffman, and different law firms do it different ways, but at Marks and Hoffman, when we're asked a question about who, any number of legal issues, who pays for the deck, who does the work on the deck, or the sewer laterals, is it common or not, we always put our opinions in writing so that the board, and when new board members come on, they have a collection of opinion letters to kind of clarify things, which I think has been helpful.
Director removal, or removal of directors and officers, excuse me. Under both the UPCA and the UCA, again, we touched on this earlier, directors may be removed by 2/3 or 67% of all persons present and entitled to vote at any meeting of the unit owners at which a quorum is present. Obviously, the meeting usually called, for the purpose of removal. I think I touched on it earlier, but just again, really want to hammer home that it's 2/3 of those present at the corresponding voting meeting, not the entire community. And again, we touched on this earlier, that the Condominium Act did not previously contain a provision on director removal before the Act 115 legislation, but it now does, and it essentially mirrors the UPCA, except for the condominium associations. You have to circulate the notice to the unit owners prior to the meeting, advising them that of the intention to remove a director at the meeting. Removal of officers is not actually codified in any of the statutes, usually spelled out in the governing documents. Steps for board removal. So again, this is very general in terms of the procedures here. For your individual association, I would say, whatever is outlined in the bylaws would be controlling. But the first thing that normally happens is that there has to be a request for a special meeting. And again, most governing documents, establish how unit owners are able to request a special meeting of the association to conduct a vote, either on the removal of a director or some other issue. Notice of the special meeting for removal, again, established under the governing documents and the act. If it's a condominium, notice of the intent to remove a member of the board has to be provided with the notice of the meeting. If it's an HOA, the statute doesn't contain the language requiring that the notice of intention to remove be included. However, best practice to keep that in there anyway and let everyone know why they're attending the special meeting that's to be called. Directed proxies, again, this is another instance where we have utilized directed proxies with clients in the past, should be circulated with the notice of the special meeting for the vote on the proposed removal of the director or directors. And steps for removal. In the event that enough votes are obtained at the meeting to remove either a director or directors, then the question becomes, okay, well, how do we fill these vacancies? A special election could be conducted either at that same meeting, assuming the votes, assuming the votes to remove were tallied at the meeting. Or alternatively, the vacancies on the board could be filled by way of appointment by the remaining members of the board. But just want to stress again, for both of these, it's subject to whatever is in your governing documents. Your governing documents may say that, in the event that a director is removed from office, the remaining members of the board will appoint someone to serve the remainder of the term, or it could contain a language requiring that a special election be conducted either at that same meeting or at a subsequent meeting held within a specific time frame. So in terms of filling any vacancies from removal, our biggest thing is check the governing documents, and because everything will be subject to what's spelled out in there. And so that actually marks the end of our presentation. And I assume seems like some more questions have popped up.
Yeah, so I see that Michael raised his hand. Before we go to Michael, there was a quick question about if a board member resigns, which leaves 4 board members and a vote must be taken, and it's 2-2, who makes the call on who would be appointed to the board?
Well, it has to be by a majority of the remaining board members present, even if it's less than quorum. So if you're at a 2-2 vote, then you need to look at a different candidate, or the 4 board members need to talk amongst themselves and see if they can reach some kind of decision. But if they're just deadlocked and they can't agree, then you need to look for a different candidate.
Michael, do you want to unmute yourself and ask your question?
I think I'm unmuted. Is that correct?
You are.
All right, very good. This may be a little arcane, but I'm talking a little bit about the concept of quorum. In our bylaws and declaration, we do have provisions that members of the association who are not in good standing, that is more than 60 days in arrears, are not able to vote or participate. Does that reduce the quorum, or is that something that the bylaw or the law doesn't even anticipate?
I think that if your quorum is 20%, it stays at 20%. It's just that person who's not in good standing does not count, even if present at the meeting, towards the 20%.
Okay, thank you.
Yeah. And there's also provisions in the act that that we can implement, that need to be affirmatively implemented, that state that individuals that are not in good standing because they're delinquent or have open violations are not able to serve on the board or serve on any committees or vote.
Yeah, thank you.
We are at the 7 o'clock mark, but I think we can maybe take 1 or 2 more questions if there's still some lingering out there.
Actually, I have a question.
Yes, Carrie, go ahead.
Hello. Hi, Rob. Hi, Rob.
Hey,
How are you? It's good to see you.
Good to see you too.
So I have an association that has the directed proxies, but they've really never been able to achieve quorum. And they have been following a procedure of if they don't have the quorum, they establish that, they call the meeting, they re-adjourn. If they don't have the quorum, which they don't, they call the meeting again and they open it up. And they're following this platform that says that by the time they call the 3rd meeting, that the quorum capacity drops. Is that still something that can be utilized within their particular bylaws, or does this new provision counteract that?
So their bylaws currently say that at the third meeting, the quorum is automatic?
Basically, yes.
Okay, I think that's consistent,
But
isn't it, Rob? with-
That is, yeah.
Okay.
That is consistent because that provision under Act 115 starts out that if an association fails to meet a quorum at 2 subsequent meetings, so then it would be the third one that would, sounds like that's what it is for your association, correct?
They're calling that meeting and re-adjourning it in the same meeting.
So you can't do that. We can't
Yeah.
all show up at Thursday night at the high school.
Yeah.
Say, oh, here's meeting number 1. We're not quorum. Okay, cancel it. Here's meeting number 2. Like you can't do it all in one night.
Okay,
Yeah.
that's what
Yeah.
I thought.
Yeah,
Okay,
no, especially if it's not a meeting for the election of the board, because then there's the notice requirements that are involved as well for the third one. So yeah, that should not.
that's kind of archaic. Okay, thank you.
Anyone else have any questions? You guys are champs. You're all hanging in. We're past 7 o'clock. So.
Yeah. Well, thank you, Rob and Rob, for this presentation. It was extremely informative. For those board members in attendance, we did record this meeting, so I would be able to send you a copy of the link if interested, or your fellow board members can either reach out to myself or your manager, and they can send along a link to the recording.